Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now this afternoon I'm looking at a book which has come to us from Palgrave Macmillan, and it's in their Pivot series, which I'll explain about in a moment. This particular book is available also as I understand it, as an e-book. I'm not quite sure, but we'll have a look at the book in a moment. I'll explain to you what it is. The title is Principled Judicial Restraint, a case against activism, and it's been written by Gerald Waltman. And my wife Elizabeth and I have written a review for this book, which we're sending to the journals and putting on the web. We've given the title of it, Restraints on Judicial Activism, Why, How and When It Should and Shouldn't Be Done. And that's the basis of the book. It's only a small book. Here it is. It's the Palgrave Pivot series. And as I say, that's the front cover. There's a spine there which has the basic information, and then there's some information again on the back. The book itself is a very small one. It runs to something approaching 100, just over 100 pages. There's an index which is at the back there. As I say, most of these books, I understand, are not available normally as books themselves. That's the front page. And there's the basic information there. There's also a series of books written by Gerald Waltman, and they're actually listed there. The actual contents, there are 6 chapters, and the contents end with a conclusion. And in fact, it indicates clearly that there is both a hardback and a PDF version of the book. And it's a special Pivot series which they have produced. The bibliography is actually at the back of the work itself. The work is continual text with some subheads, and as I say, you have the bibliography itself at the back. And what you have at the end of each chapter are a series of notes, effectively to deal with the subheads, the footnotes, which you would have normally in some versions of the book. Now, it's a very important book, I think, from the point of view of jurisprudence. And what I have to say here really covers the basis of why we thought the book was certainly one that would be of great interest to certainly those studying jurisprudence at a higher level. It's all really about the American system, but there's quite a lot that we can learn, of course, in England and Wales and the United Kingdom systems as well. Because what we say is that although this book focuses strictly on the American legal and political landscape, it will nonetheless be welcome by deep-thinking jurisprudence on both sides of the Atlantic. And that's really where we come in. The author is Gerald Waltman, and he's a professor of political science at Baylor University in the United States of America, where he teaches constitutional law. And as indicated by the subtitle of the book, it's published by Palgrave Macmillan and makes an eloquent case against what is described as judicial activism, which means that it advocates restraint on the part of judges on America's Supreme Court who disagree with specific majority decisions of the court. And it's an interesting point because it's one that we've had raised certainly in this country with the role of the House of Lords in dissenting judgments in the past and so on. And Waltman goes on to say many people argue that the court should adopt, and that's the Supreme Court in America, should adopt a more restrained posture across the board. An interesting point from a constitutional viewpoint. What will resonate most, we think, with UK readers is the concern that the court is damaging its legitimacy by wading into so many controversial political issues. And here, of course, UK readers will certainly recall instances when there's been a tug of war, so to speak, between the decisions of the courts and the will of Parliament. And we know, of course, that Parliament is supreme. And there's another quote we have here. "I have long been of the opinion," says Waltman in the preface, "that the modern Supreme Court has assumed too large a role in our political life. He therefore calls for a theory of constitutional government rather than a set of prescriptions for the court." The stated aim here is to set out just such a theory in the book. The result is a rather fascinating read, we feel, which, amongst other things, sheds considerable light on the salient points as well as the nooks and crannies of the American Constitution. And the core of the book is the fourth chapter, which is entitled A Constitutional Theory of Judicial Restraint, which commences with commentary on the maladies of judicial activism, especially the stentorian form that it has taken under the current court. So quite a lot of criticism here aimed at the American Supreme Court. While a heightened judicial role could be appropriate and necessary in certain circumstances enumerated in the text, basically what is needed, says Walkman, is a constitutional and judicial philosophy that includes judicial review but simultaneously grants a healthy respect for how people wish to govern themselves. Now, who could or would disagree with that except a particularly stentorian or dictatorial judge? Now, we've seen some of those in the past, and I think, as I've said before, in the concepts of legal theory and jurisprudence, this book has a minefield of suggestions which are well worth looking at as far as England and Wales are concerned. Let me conclude by saying this. As a clearly argued and thoughtful exploration of this and other issues worthy of urgent examination, this book, which is available online as well as in a hardback edition, is quite a find. And we basically are no doubt welcoming the view of what's been put in this book for all those who are students. And also we feel that it's quite an important book for both practitioners and judges everywhere to read, especially those in the common law jurisdictions. And the publication date is cited at 2015. Let me just show the book again. Because it's online, you haven't got much by way of artwork at all. There's the front, the spine, and then the back. There's very little actually in terms of the exterior. But what you have got with the book itself, there's the front again. It's Palgrave Pivot series. What we've got in the contents section, where we are now, how did we get there, parts 1 and 2, A Constitutional Theory of Judicial Restraint, which is actually the meat of the book, objections and conclusion. And then the actual book is well written, very well written indeed, and in fact he goes straight to the point. He does mention a couple of quite substantial cases as well, but of course they're nearly all from the American jurisdiction itself. Do read the preface, which actually sets the scene quite nicely, and then there's an abstract for each of the chapter headings, so it does come across as though it's effectively a thesis. Anyway, thank you to Professor Waldman and Palgrave for producing this excellent book, which is well worth reading. And it's the sort of book, if you're looking for a first, where you need the extra information to just give you that extra few marks to get you to the top. Good luck, and thank you very much to all concerned. Bye-bye.